If I can have your attention, please, we'll start the next panel, and we'll hopefully get you out of here at a decent hour so you can have some drinks and some fun after. And as you can see, we have another microphone working. Yay! All right, so we're going to keep our fingers crossed that it works the entire time. This is our search panel. We're going to be talking about searching the ESI before it's collected formally and sent to a vendor. So we're going to, and our panel today is, as you see, this is our biggest panel so far. We've got 5 folks on it, and these folks are bringing a wealth of information and different perspectives, and I hope you feel free to use their expertise, ask a lot of questions, and what we're going to do is let them introduce themselves, and we'll start right here, Dave.
Thank you. I'm Dave Norman. I'm with Guidance Software. I am the Regional Director for our Professional Services Division, 14 states, north central U.S. Been involved in e-discovery, litigation support, things of that nature for about 8 years now.
I'm Joanne Fair from Wendy's International. I manage the technology function for the legal department at Wendy's. Well, I guess we're also Wendy's Arby's Group. So I manage that function for legal technology as well. And we have several folks here in the back. So we're paralegals who I hope that you'll pick their brains too about how we do this within our company.
Hello, my name is Alex Goff. I'm a litigation support analyst with Squire, Sanders & Dempsey. I've been in a law firm for 2 years. I was on the vending side for 13 years, so had kind of a nice mix of experiencing both sides of life, and looking forward to speaking with everyone today.
Hi, I'm Kurt Layson. I'm with Autonomy. We're a UK-based company. I've been with the company about 8 years, and I specialize in what we call meaning-based computing. We use our technology in a lot of different ways, and primarily in the last 2 years, the most frequent way, due to certain conditions in financial markets, has been with litigation.
I'm Doug Matthews. I'm a partner in the litigation group at Vorey, Sater, Seymour & Pease here in Columbus. And I'm also part of our electronic discovery core team, which really supports the whole firm on ESI.
And we're still passing around a single microphone. It's a different microphone, yes, so we're moving up in the world. Okay, the way we've tentatively planned our panel is that we've asked each person to take the lead in a discussion. And we will go point by point. Please feel free to ask questions, or if you have something to add, feel free to do that as well. And we are going to start with Doug.
I guess I'm speaking first on a topic that was very similar to what the previous panel was, and that's sort of the importance of the discussions, either both among the client and outside counsel and with opposing counsel. And I really want to second what the previous panel said. The importance of the discussions among the IT people, your inside counsel and your outside counsel at the very beginning are absolutely critical. It really is a team effort where, as outside counsel, you need to go in and understand where the documents are, where the relevant documents are, who are the relevant custodians, and where are they located, and what are the issues involved in preserving them, being able to search for them. And you're working with the client on the merits of the lawsuit, is to sort of identify who the relevant people are. And it really does have to be a team effort so that you understand what's going on, so that you can work with the client to do the right job, as well as the client educating you so that you understand what's going on, so you can report to opposing counsel in the court. With opposing counsel, I think everybody's familiar with the traditional adversarial, non-transparent system. But I really want to second what everybody else has been saying, that we really are shifting in ESI to a world where cooperation and collaboration and transparency are critical. More and more, if you're going to be doing a pre-collection search, you're at least going to want to strongly consider working with the other side to develop agreement on search terms. You may even want to consider more and more, you're seeing people doing an iterative process where you do some back and forth, where if you have a dispute, you take a smaller sample, run testing, see whether or not you're getting, are you getting responsive documents, are you missing them, are you getting a whole lot of irrelevant information, and work with small samples to try to narrow and focus your search terms. And to do that, you really need to be engaged in this transparent discussion with the other side if it's going to work very well. As they commented before, everybody is really encouraging this. The courts, the commentators to the rules, the Sedona Conference. I mean, the Sedona Conference Cooperation Proclamation, there are a number of courts who affirmatively signed on to it, including our local business judges, the new business docket we have here in Franklin County. Even those judges that haven't signed on to it, I think a lot of them are still expecting and demanding that there be a lot of cooperation among opposing counsel. And the most important reason to do it is I think ultimately it's more efficient for your client to have that sort of transparency and cooperation in most instances. If you don't, you just go out and do it on your own, you run search terms without discussing with the other side, you're subject to a lot of second guessing down the road, criticism, where you may end up having to redo searches. And if it somehow has impacted how you've gone about preserving documents, you could be, you're more likely to get sanctions. So just to avoid those risks, in many cases that is the better way to go. I do think there's a lot of hostility to this because it's just not the way things have been done. But if you're really looking at what's in the best interest of your client, you need to at least strongly consider using cooperation and transparency. You know, I think a lot of times it depends on what's the thoroughness of my opposing counsel. Are they likely to be lazy and not cooperate or not care if I'm not going to second guess what I've done, then I might be more willing to not cooperate. But if I've got an opposing counsel who's contentious and I may be even more interested in trying to cooperate, because even if they're not cooperating and I'm at least putting a good face forth with the judge that I'm attempting to do so. So when I had a case when we asked at the beginning, all right, I suggest we produce with, we're going to use TIFF images with the following metadata, and we got back a letter that said, we'll produce in accordance with the rules. That was it. I knew that if we ever went down to court on that, I was going to at least be in a better position with it, if this was a court that was interested in wanting the parties to cooperate. And one of the things that we talked about was when you're doing an early case assessment, when you're searching for things before collection, the question was, all right, should we search everything? I think it's rare that you've got a case where you want to try and search everything, even in an early case assessment. And that's one of the things that you need to do when you're working with your inside counsel at the beginning, is to target your initial collection, using dates, key and non-key custodian, your file types, your volumes, where things are located. Because focusing your collection, or focusing even your pre-collection search scope, you're going to reduce the processing costs. And trying to collect everything can be virtually impossible when you start looking at things that are on backup, portable media. You're still better off even doing a pre-collection search of narrowing the scope of what it is that you're going to look at.
I have a question I'd like to ask. You talk about transparency. One of the challenges that I've always found is how do you convince other partners at the firm to be transparent? And I'm talking about how you communicate with the other side about keywords and date ranges and such, because most of the time what we see is just the 911 on Friday afternoon that just needs to be done. And we don't necessarily know if kind of the relationship between both sides is hostile, is contentious, or open and cooperative. What are some of the things that you try to do to encourage other partners to be transparent?
I'd love to say that it's really easy and that everybody adopts it right away, but you're right, it absolutely is a change in the landscape, and so that it is going to be a slow process. And I think all that I've been able to do is really go in and try to reason with people and lay out here, and realistically, you can't be a fear monger and say, oh, if we don't do this, we're going to get sanctioned. You really have to do is take it on a case-by-case basis and lay out, all right, here are the risks. If we do it this way, and later on they disagree with the steps that we've taken, the search terms we've used, are we going to be sanctioned? We can't ever claim that we've produced every document responsive to a certain request. All we can do is sort of identify what it is that we've done, and here's what the results were. and really point out that the costs and benefits of cooperation in many cases are going to lead toward cooperation.